Welcome to the Small Business Tax Savings Podcast, your weekly dose of accounting and tax tips specific to small business owners. You will be on your way to growing your business and paying the least amount in taxes as legally possible. Here's your host, Mike Jesowshek, CPA.
Hello and welcome back to another episode. And today we're on part 3 of a mini-series that we're doing on legal items. And for this mini-series, we have Andrea Sager from the Legalpreneur on. The first week we talked about, do you need an LLC for your business? So if you have not checked out that episode yet, do so now. Last week we talked about what contracts do you need for your business. And this week we're kind of finalizing this mini-series on why do you need a trademark or copyright for your business? So Andrea, welcome back to the show.
Thanks for having me.
So let's dig into that. First off, kind of what is a trademark? What is a copyright? And then let's go into why do I need those for my business? Why are they important to what we're doing on an everyday basis?
Yeah, so trademarks and copyrights are actually two of the most misused terms with entrepreneurs. And it is really important that you do know the difference. And I'm going to tell you the easiest way to know the difference, super simple to remember. Trademarks are your branding, your brand identity, your brand name, your logo, a slogan, a product name, a podcast name. Anything that has a unique name within your business, it can probably be protected with a trademark. On the other hand, we have copyrights, which is your content, your creative work, your blog posts, your videos, your photos, this podcast episode recording. This is protected with a copyright. So any of the consistent content, the creative work, all of that is protected with a copyright. So trademarks is branding, copyrights is content.
Excellent. And so when we look at a trademark or a copyright, what needs to be done to actually secure them and what purpose do they serve? So, if I'm just operating as Joe's luxury vinyl flooring manufacturer, why do I need a trademark or copyright? Why can't I just operate under that name? And when does it make sense maybe to do a trademark or copyright?
Yeah. So with copyrights, you actually automatically have protection the moment the work is created. You have federal protection. So across the whole United States, as long as it is unique and original, you automatically have that federal copyright protection. You don't need a registration. For trademarks, you do need a federal registration in order to have federal rights. And this can vary whether you need it or not, but depending on, hey, are you an online based business? Are you doing business in more than one state? Or are you just a local business? Because it's two completely different stories when it comes to intellectual property. But let's talk about Joe's vinyl flooring manufacturing. If Joe has this vinyl flooring and he actually has a really unique design in a flooring pattern, that could be protected with a copyright. Now, a lot of them are just generic patterns, not really anything that can be protected. But if Joe comes up with a pattern that can be protected with a copyright, you want to make sure that's protected because guess what? Not only can you make money now off of selling this vinyl flooring, you can license this pattern to other manufacturers, or you can license the pattern to clothing manufacturers. This pattern itself can be licensed to make many other things. And because you created the pattern, you're the only one that can actually monetize it unless you give somebody else permission, which is a license.
Got it. So when you look at that pattern in a copyright, is there, you mentioned that from a federal level, there might not be anything that needs to be filed. So if I have this beautiful pattern that I built out for the flooring, what is it automatically copyrighted? Is there something specific that I need to file? And then how do I license that out and kind of go from that standpoint forward?
Yeah. So in order to have the copyright rights, it's automatic. However, if not saying you want to sue anybody for copyright infringement, however, in order to sue somebody for copyright infringement, you do have to have that registration. And if you have it before somebody infringes, you're eligible for what's called statutory damages. Long story short, easier to prove damages in court for a copyright case, and you get attorney fees if you have to sue someone. Now, the reason why statutory damages for copyrights is important is because of the damages piece. It's very hard to actually prove damages in a copyright case. So let's say that you have this pattern and you make $100,000 selling the flooring. And then a bigger manufacturer comes along or a clothing manufacturer comes along and they use that pattern for clothing or something else, and they make millions of dollars. And you're like, "Hey, that's my pattern. I should have that money." And so you sue them for copyright infringement, and you wanna say, "Hey, I was damaged millions of dollars because that's what they made." But that's actually not the case, because you may not have been damaged at all. That actually could have helped you grow your
Mm.
brand and get awareness around your pattern. So just because somebody else made money with your copyrighted work, it doesn't mean that's what you were damaged. That's why it's really hard to prove damages in a copyright case, and that's why you do wanna actually get the registration. That way you're eligible for statutory damages. One of the biggest things, especially if you have a website or if you have an online presence, one of the quickest ways to get in trouble with copyright infringement is using photos that don't belong to you. So if you have a website and you find pictures on Pinterest or Google, you actually can't use those. That is 100% copyright infringement. And that is by far the number one reason clients come to us, month after month, and they're like, "I haven't even like I posted this blog post years ago and I just now got this cease and desist letter." Or, this was posted on Instagram 3 years ago. It got, 5 likes and they're suing me for it. The reason is because these photos, a lot of the photographers, they're using there's it's really easy now to use software to figure out, okay, where on the internet is my photo being used without my permission? Then they go and they send a wave of cease and desist letters, and then they see who pays. And quite frankly, it's becoming a business model for some photographers, which is not okay. But it's part of being a business owner. You have to be educated to know, like, hey, what are all the ways that I can get in trouble, and I need to make sure I avoid those.
Got it. So, just a kind of question on that. If I write a blog post and, we obviously do a ton of blog posts and content and everything that we're putting out there, there's automatically a copyright on there. When does it make sense to make that registration? Is there a certain, say, income level? And as well as if you did that registration, would it have to be for every photo you do, for every blog post you do, or is it like kind of a blanket for the work that you're doing?
It depends what medium it is. So, according to the Copyright Office, blog posts are not downloadable. So, you can do like your whole backlog of blog posts. Podcasts, different story. Photography, different story. Photographs, you can do a collection. So, if you're a wedding photographer, each wedding that you do, you can file one application, but it varies based off different mediums. And it's really not about the money, it's about, are you being ripped off? Are people copying you? Because a one-off here or there may not be that big of a deal unless you're consistently finding people taking this one piece of content or this one photo. Or so we work with a lot of designers, and a lot of our designers, we have a specific monitoring program for them because they'll post a new design. The next day, 100 different people will be selling that design. So we have them in the routine they send us the designs before they actually publish it. We submit those applications. That way, when those people do start ripping it off and we start reaching out to them, we say, hey, look, this is copyright infringement and we're eligible for statutory damages. So they just end up removing it most of the time. If worse comes to worse, we do sue them because they're making a lot of money off our clients' designs. So it's a matter of, are you consistently being ripped off? Now, if you had, one blog post that somebody took once and you reached out to them and you said, hey, not sure if you know, this is actually my original blog post. Please remove it, and they do. And if they do remove it, I wouldn't take it any further. If nobody else infringes on it, it's completely up to you if you wanna file. But unless you're being consistently ripped off, I'm not gonna say you don't need to, but our clients, very
Mhm.
small business owners, it's our job to make their budget go as far as possible. So for those business owners, if money is an issue, I tell them, "Don't worry about it unless you are consistently being ripped off."
Makes sense. And as far as filing for a copyright, filing that paperwork, what is typically like a cost or a rough idea on pricing and process for that? Is it just simply submitting something, you're done? Do you have to check back on it? Does it take a while to get approved? What does that look like?
Yeah, so the copyright process, it is depending on the type of application that you file, it depends on the medium. It's anywhere from like $30 to $60. My law firm, very middle of the road, people are cheaper, people are more expensive. 450, we include the filing fee. And if you need to file more than one application at once, we'll typically just cut you a deal if we're just filing different applications. It's really not that long of an application. You can get it submitted probably like 20 minutes once you get the hang of it. And then it's really a toss up anywhere from 2 to 7 months. I would
Mhm.
say the more complicated the medium, the longer it takes. And when I say medium, so if it is a photo, it's easy for the copyright office to look up that photo and figure out, okay, does this look like they're the original creator? And does this look because photos are really easy to tell, like, hey, this is their original work. But if it is song lyrics, perhaps they may have to do some digging to figure out, okay, is there any substantially similar work out there to where we shouldn't grant them this registration?
Makes sense. So let's flip the conversation. We talked a lot about copyright. Let's go back to that trademark idea. And again, this is your brand, your logo, your name, those types of things. What does the registration process look like for this? Is there a certain, again, is this something you recommend all business owners do with their name trademark? Or is it once you hit a certain level or a certain style of business? What does that typically look like?
Your money is typically better spent on a federal trademark application than a federal copyright application. But if you're a local business, you're probably not eligible for the federal trademark registration anyway. For federal trademarks, you have to be doing business in more than one state. If you're an online business, you're typically reach this threshold. If you have a podcast, if you have a brick and mortar store and you have a location in 2 different states, you're good. But if you have like a local bookstore, don't sell anything online, only have one location, you're probably not even eligible for the federal process. And that's fine. You can still get a state trademark. But if you're eligible for federal, don't waste your money on a state trademark. But the federal process, it is lengthy. So the application fee is $250. And right now, you're looking at least a year for the total process.
Mm.
And for my law firm, again, very middle of the road. People are cheaper, people are more expensive. We charge 1950, and that includes the trademark search and the trademark application. The search, so if you go to any trademark attorney to file a federal trademark application, they're gonna require a search. If they don't, I would actually be very weary about that because of the time and the cost of a trademark application. You always wanna make sure the attorney is doing a trademark search because at the end of the day, I'm not going to file an application if I know you're not going to get approved. And that's what the
Mhm.
search is for, to figure out, okay, do you have a good chance of getting approved? And once you filed, the next step is figuring out, okay, is the trademark office letting you proceed or are they going to issue an office action? It's just a refusal. You can overcome refusals. And so during our search, we're looking at, okay, what are the potential office actions that we may get? And do we think we will have a good chance at overcoming these? And so in that search, we'll tell you, hey, good chance of getting approved. And we think you're not going to get any office actions, or maybe you will, but we still think we'll be able to overcome them.
So when you look at a trademark, is it you have to file a separate one for your company name and then maybe your colors, your logos? Like, is it all encompassing, or do you have to file a bunch of different kind of trademarks for each different item that you have?
So it's a new application for every different thing that you want to protect. I always tell business owners, get started with your brand name because that is the main identity of your brand. Then go with your logo if you have one that you're happy with, especially newer business owners. I tell them, look, unless you're very, very happy with this logo, I wouldn't waste your money unless money is not an issue. And the reason is because a lot of times you just end up changing logos. So until you have a logo that you're happy with, that's when I would file for the logo. If you go look up Meta or Facebook, they have like 10 different logos filed and they're slightly different, but I mean, they're Facebook. They file, hundreds of trademark applications. But for small businesses, I would number one start with your brand name. And then once you're happy with the logo, start there. If you have a slogan that people really know you by, absolutely. Product offerings, any service offerings that people really know, like this is identified with them. So when I had just my law firm, Andrea Sager Law, I have a trademark for that. And then we had the Legalpreneur membership, which was in the law firm. It wasn't in the Legalpreneur company yet. We also had the trademark for the Legalpreneur membership. So it
Mm.
wasn't just, Legalpreneur, the company, it was just a service at the time. So if you have things that identify your business, your brand with a product or service name, you also want to protect those. And as far as timing wise, I don't want to say like it's specifically a number. If money is not an issue, you absolutely want to file those trademark applications as soon as possible because that's everything. Like that's your whole brand. You do not, what you want to avoid is a rebrand at all costs. And I tell clients, look, if you're starting out and you're trying to just test the water, you're trying to see like, hey, can I make this work? It's really when you make that shift from I'm testing to now you have momentum. You're like, hey, this is a thing. Like I'm a true business owner. I am making this work. That's when you want to make sure you file that trademark application to get that registration. Because at the end of the day, a rebrand is not fun at all.
Yeah, and so just one final question to kind of wrap this up is when we talk about the trademark, if we go back to that Joe's Vinyl Flooring and we see that Joe's business is just killing it, and I'm a vinyl flooring guy and I have Mike's Vinyl Flooring, and I'm like, hey, I noticed he doesn't have a trademark, so I'm going to change my name to Joe's Vinyl Flooring so that now I can basically take his URL and do all these other things. Is that stuff that's happened? Like, can somebody actually do that, or is that kind of the main reason why you would look at this trademark idea?
So it has happened, but it is rare that that happens because it's not just, okay, I started this business 10 years ago. I never filed for anything. And then somebody else came along. Whoever was in business first has priority to the name. So if
Got it.
you see somebody that has this business name and you're like, oh, they don't have a trademark, I'm going to go trademark it. Well, yeah, you can go get approved for the trademark. But if they then come after you, or if you want to go after them, that's going to open a can of worms. And you're actually going to lose that registration if they fight it because they have the right to the name because they were in business first. But I will tell you, I've done all those proceedings, and you're gonna end up. So for the person that's listening, it's like, oh yeah, then why would I even need to file if I can just come back and get it and fight for it? Because that's gonna cost you 30, 40, $50,000
Yeah.
instead of just spending, 250 to file on your own or 2,000 to work with an attorney up front. We've had a number of those cases. They're never fun. And every single time, like, I wish I would have just spent the money from the beginning to get protected.
Yeah, that makes complete sense. It's again just that idea of protection and setting things up, and even as an LLC, if you're operating as a sole proprietorship and you do something wrong or by accident, you still might be able to win a case if someone sues you. But it's all those legal fees that went into
Yeah.
that where they could have been avoided if
Yeah.
you paid a little bit up front to kind of protect against that. So, Andrea, thanks again for joining us. Again, this is part 3 of a mini series that we did on legal things you want to be aware of and start to implement in your business. We started out by saying, do you need an LLC for your business? Our second episode was what contracts do you need for your business? And of course, we finalized this mini series today with, why do you need a trademark or copyright for your business? So, Andrea, I really appreciate you taking the time and coming on the podcast. And again, share with the audience kind of what you have going on, where people can find you, what are some things that you're up to right now?
Yeah, thank you so much. This has been so much fun. Find me on TikTok, our podcast, Instagram, YouTube at The Legalpreneur. And I also have the book coming out, Legalpreneur, The Business Owner's Guide to Legally Protecting Your Business. And if you want all access to your own attorney, check out our Legalpreneur membership.
Yeah, that's excellent. We'll have a bunch of show notes and links to those in the show notes. And as I've been kind of going along the series, is what Andrea is doing in her company is very similar to what we do. Their style, the mediums that we're a part of, and so if you like our style way of doing things for accounting and tax information and learning in that area, I think you're really going to love kind of what Andrea is doing over at the Legalpreneur as well. So, Andrea, thanks again for joining us, and we'll have you on soon.
Thank you.
This has been another episode of the Small Business Tax Savings Podcast. If you enjoy our weekly episodes, please leave a review and share with other business owners. You can find previous episodes and more information at www.taxsavingspodcast.com. Thanks for listening and have a great day.